Hello, everyone. Hello, mother of the bride. That's what the license said. Solemnize. Yeah, it's like doesn't it feel like I'm about to do a Torah portion? JD made that joke. JD said, "I hope there's. Can we throw candy at him?" Yeah. Just so you know, there are hundreds of people online, so don't feel bad. Yeah. So. Yeah, but we parked over here. Yeah. And you're like, was this at the JCC? Right? You're like, was this at the JCC? No, I'm teasing. I'm teasing. No, we'll give a few minutes. Yeah, we'll give people a few minutes.
Yeah.
I think that's fast. I think
that one is fast. I've got 7:31.
Yeah, same. Kate is having trouble with audio. Okay. Well, my phone is off because I'm giving it my full attention. And now it's like, JD, turn on your phone.
Right. Help mom out.
Yeah,
Go outside. Help mom. The undermining never ceases.
Oh, I just have to it's like, great.
I think I'll start at 7:33.
Great. Okay. You don't want to silence. I don't. Wait, did you find it? Paul Tucker's running for Essex County DA, and he used to be chief of police of Salem, and is currently a state rep for Salem. He's done a lot of work with the ADL, JD. You should, yeah. I just, just. Too much? Everything, JD. Was he? I find sometimes those events can be a little much. Good. Did she win her did she win her unopposed? Yeah. Oh, she won. Okay. Sure did. Yeah. Someone cut in line, and I was like, "Hey, what are you doing?" And then someone was like, "I'm gonna call the cops on you." It got really. They ran out of ballots. Yeah. It's working? Okay, great. All right. You could just say he runs various law programs at the university.
Yeah. All right. Good evening, everybody. Thank you for joining us, both in person and from the convenience of your home. I think we might have people who stretch the country. I believe that there are people in Seattle zoomed in, and probably people a quarter mile from Shirat Hayam who are zoomed in. We're grateful to have everybody. Tonight we will we'll learn from Dan Urman, lecturer, professor at Northeastern University, focuses on law, politics, but for me, a good friend. And I'm really just grateful, Dan, for your time tonight, and and for the thoughts that you've put into helping us understand what might become a legal decision, but you can tell us more about all of that.
Great. Thank you so much.
Dan.
Okay. Thank you. Hi, everyone in the room and on the Zoom. I don't know if there's anyone who's monitoring the chat, but What I plan to do today is talk for about a half hour max. And then what I would love to do is open it up to conversation, questions. If I don't know the answer, I might be able to point you to a resource that has the answer. But my goal tonight is to provide an overview of what got us here. And by what got us here, I mean we are really on the eve, and by that I would say fewer than 7 or 10 days. We are really on the eve of the Supreme Court being prepared to overturn Roe versus Wade, the January 1973 decision that said the general right to privacy encompasses a decision for a woman whether or not to terminate a pregnancy. All right, so lawyers would call that the holding. All right, this is a January 1973 case. So when you hear about Roe v. Wade, it's the case that says the 14th Amendment right to privacy includes the right whether or not to terminate a pregnancy. As you can imagine, the story begins quite a bit earlier, so I think what I want to do is talk a little bit about the background of the Roe v. Wade decision in 1973, chart the history between Roe and present, and then talk a little bit about the leak that some of you are probably familiar with that occurred at the beginning of May, and then my thoughts on what path we might have going forward. Does that sound like a plan? You don't have a choice, but it's polite to say, does that sound good? Like when someone says, do you want to hear a story? You're going to hear the story. So, okay. So big picture, the debate over Roe v. Wade is a huge debate. I just want to say from the beginning, it's a complex debate. There are moral, there are ethical principles, there are limitations to my understanding as a privileged white male. I just want to acknowledge that. I think the consequences of Roe being overturned are going to fall more harshly on marginalized communities. We can obviously get to that at the end, but big picture, the roots of the case of Roe v. Wade are really in the 1960s. Okay, so in the 1960s, the Supreme Court ruled in a case called Griswold v. Connecticut. Griswold v. Connecticut involved a law that criminalized contraception for married couples. Some of you might be surprised that that was the case, and that it was Connecticut, which is a state we currently associate more, I think, with quote-unquote liberal politics. But ultimately, the Griswold case led the Supreme Court in an opinion to say that the right to privacy is older than the Bill of Rights itself. It was basically saying there are some things that governments cannot do. And they said this right to privacy, and it was really marital privacy in the bedroom. This right to privacy is something that the state can't regulate. This is a private matter between married couples. And the dissenters, now remember, this was not a unanimous opinion. The dissenters in the case of Griswold versus Connecticut said, basically, I'll put this in non-lawyer terms, they basically said, this law is uncommonly silly. This law is something I would never vote for. And as you could probably imagine, there's a but coming. And they said, but the Constitution doesn't have an explicit right to privacy, and as judges, it's not our job to invent the right. What I'm basically saying is that's a preview of the debates that have been going on. Of course, the debates are much more complicated than this, but the basic preview is, are constitutional rights only what is written in the Constitution, or are there deeper and more fundamental rights somewhere else? The leaked opinion addressed this, and I just want to say, Griswold was really a preview of Roe. Okay, so it's 1965, Griswold gets handed down. Then there's a case actually from here in Massachusetts. It's called Eisenstadt v. Baird. And Eisenstadt v. Baird takes the Griswold rule, married couples have the right to privacy, married couples have the right to contraception, and it says, and unmarried couples, right? So Eisenstadt sort of extends the logic beyond what was then husband and wife, all right? So I just want to kind of stop the music for 1 second and sort of put us in 1971. There's a lot happening in the early 70s, but the biggest thing that was happened in 1968, which is Richard Nixon winning the presidency. Historians talk about hinge elections, elections that if they went a different way, history would be so different, and of course, history would always be different, go different ways. But Richard Nixon, who was president from 1969 until August of 1974, so basically a term and some change, was able to nominate 4 Supreme Court justices. So the reason I'm stopping at 1971 is that Richard Nixon transformed the Supreme Court from what we know as the Warren Court, which was the sort of high watermark, the peak liberalism of the Supreme Court. And Nixon campaigned this way. Many of you might recall this, where he said the Warren Court was an activist court. He said they gave criminals too many rights. And he said he would appoint judges who were strict constructionists. And I think the way that I would classify strict constructionists, if any of you remember the Amelia Bedelia books, which I still love, it would mean you just read the words as they're written, even to their logical absurdity, just like our friend Amelia Bedelia. So he promised this, and Nixon put 4 people on the Supreme Court. He had Warren Burger replace Earl Warren. Then he had Harry Blackmun replace Abe Fortas. And then he had Lewis Powell and William Rehnquist replace John Harlan II and Hugo Black. And what this meant was that from 1971 forward, there was never a quote-unquote liberal majority on the U.S. Supreme Court. That's just an important thing for everyone to remember. The last time there were 5 liberal votes, and I just want to acknowledge that calling justices conservative and liberal is imperfect, but in my view, largely accurate if we classify what means liberal and what means conservative. I feel pretty comfortable putting the justices in different camps. So what that means is from 1971 to the present, we have had a majority of justices who can be called moderate or conservative, but not liberal. Okay, why is this important? We'll get there. Okay, so in 1971, Harry Blackmun joins. He's actually the 3rd pick. For those of you who want to do additional summer reading, I wouldn't call it beach reading because it's just too nerdy, but Linda Greenhouse, the Pulitzer Prize-winning columnist for the New York Times, has a book called Becoming Justice Blackmun, and she was given private access to all of his papers, so it's fascinating. He was actually a very humble person. Now you see Supreme Court justices going around treated like royalty. He always flew coach, and people would ask him what he does for a living. He'd say, I'm a lawyer in Washington, right? So he was actually a pretty down-to-earth person. Richard Nixon had tried to appoint two pretty conservative judges before Blackmun, Hainsworth and Carswell, and they were rejected for a number of reasons, including that they were not very good at law. And ultimately, this is how Washington used to work. Warren Burger picked up the phone and called Nixon and said, I've got the guy for you. We went to kindergarten together. He was best man at my wedding. So it just wouldn't happen now, I don't think, right? Where Chief Justice Roberts would pick up the phone and say, like, I've got the right person. It's just not how it works anymore. But he said, how about Harry Blackmun? So he was the third pick. And early on, Blackmun voted largely in step with Burger, and they actually called them the Minnesota Twins, kind of like a pun on the baseball team. All right, so that's the context. In 1972, the Roe case is pending, okay? It involves two states. It involves Georgia and Texas. So Wade is actually Henry Wade, the criminal prosecutor in Texas, and then the Georgia case is called Doe v. Bolton. Georgia basically said you could have abortions during the first trimester, but restricted it pretty harshly after that. And Texas had criminalized all abortions. And the case got argued, and they were waiting, but there were only 7 justices on the court at the time because Harlan and Black were sick and retired. And Blackmun didn't like that. He thought for such a momentous case, it would be better to have the full 9 on the court. I mean, a quorum is 6, it would have been okay, but Blackmun cared about the legitimacy. So they waited until Rehnquist and Powell were confirmed, and then they reheard the case. This is a history a lot of people forget, and actually we can relate it to now, where some people are hoping that they find a reason to hold over the cases and re-argue them. It won't happen, but it's a fun idea. They re-argued Roe, and they handed the case to Harry Blackmun, who I believe at first they thought maybe would write a narrow ruling saying these laws are vague, these laws are not specific. Blackmun had a free summer, and he spent it at the archives of the Mayo Clinic, where he had once been general counsel. Life is funny that way. And he respected doctors because he had been a lawyer for the Mayo Clinic. And if you read the original Roe opinion, you'll see that it really has a lot of language respecting the relationship between the doctor and his, and I said that on purpose, his patient, right? In a way, it was the court deferring to a male doctor and his treatment of a woman. And it reads that way in my view because that was how Harry Blackmun sort of saw, which is, well, doctors say this is important, and he deferred. So ultimately, the case came down in January of 1973, and it was 7-2. A lot of people forget that. It was not 5-4. There was not one vote in the balance. It was 7-2. It was written by Harry Blackmun, and the 2 dissenters were William Rehnquist, who was the newest justice, and Byron White. And Byron White was a JFK appointee. He had been on the Supreme Court since the early 60s. He was, I guess what you could say, was an old school Democrat. And his view was, I'm liberal, but I just can't see the right to privacy. This is something better left to elected officials. This is better left to legislatures. So it was a 7-2 opinion. Was it a huge deal at the time? Most newspaper headlines, which is what historians use, suggest that it wasn't. Why? LBJ happened to die the same day. So if you look at the huge headlines the day that they handed down Roe v. Wade, it was the second story. It was not the biggest story. The biggest story was that LBJ had died. The other reason that it was not a huge, huge story was the opinion was mostly in line with how the public felt, which is about 60 to 65% of Americans said that abortion should be legal, especially the first 12 to 14 weeks, okay? So we look at, you know, we look at history backwards, but at the time, 7-2 opinion, majority of the justices were Republican appointees, and the opinion basically said that the right to privacy encompasses the right to terminate a pregnancy, and it uses what is called a trimester framework. For the first 13 weeks or so, the state cannot intervene. Women have a almost completely unfettered right to terminate a pregnancy. The next trimester, the second trimester, the state's interests increase. And in the third trimester, it should be very rare if you ever have to terminate a pregnancy, and mostly it should be for health reasons or to save the mother's life. Okay, so Roe v. Wade lays out that framework and introduces the concept of what is called viability, which is ability to survive outside the womb, and basically says no restrictions can prohibit abortion before viability. Okay, I just said a lot, but that's the state of affairs in 1973. The parties were not as sorted, S-O-R-T-E-D, not S-O-R-D-I-D. The political parties were not as sorted out as they are. If you say now, which political party is more associated with being pro-abortion or anti-abortion, I think everyone can immediately answer that question. But back then, there were Catholic Democrats, including Ted Kennedy and a young senator from Delaware, Joseph Robinette Biden, who were absolutely anti-abortion. So the parties were not fully aligned this way. Believe it or not, in 1973, the profile of the person that was the most pro-choice was a Republican with a college education. So if you were going to ask which political party is a Republican with a college education. Okay, so what happens? Well, I think a lot of people like to say that the opinion came down and then the public, you know, polarized and got mad and hasn't agreed since. But I think that is sometimes missing the role that political strategists played in using the issue to further polarize. So basically, let's go to 1976. In 1976, you had an election between Jimmy Carter and Gerald Ford. 1976 is the first time that the Republican plank contained language that said abortion is wrong, there should not be abortion. But Ford did not want to advocate for a constitutional amendment to overturn Roe v. Wade. Jimmy Carter was fairly uneasy about abortion too. He won the election, and as people might remember, in 1976, the more socially conservative and the more anti-abortion candidate was a former governor from California named Ronald Reagan. So Reagan loses in 76 when he's trying to get the nomination and starts to gather political support and power, and a lot of that came from anti-abortion activists in the time between 76 and 80, okay? Jimmy Carter, who everyone probably remembers was a self-described evangelical Christian, right? He alienated large swaths of evangelical voters for lots of reasons, both principled and petty. If you want to read, there's a great book called Reaganland by Rick Perlstein that goes into this. Ultimately, by 1980, Ronald Reagan and lots of political activists were able to rally around the anti-abortion cause. The GOP plank had become stronger and basically said that the Republicans from 1980 on were strongly anti-abortion, and then Democrats had sort of realigned into more liberal and urban coastal elites. And then from 1980 on, Democrats were the pro-choice party mostly, and Republicans were the anti-abortion party mostly. Couple more things happened. So Ronald Reagan wants to transform the Supreme Court, knowing that the best way to get rid of abortion is to change the composition of the Supreme Court. So just want to pause for a second. In 1980, there's nothing close to a majority that was going to overturn Roe v. Wade. Remember, it's only been 7 years, right? And I'm going to basically argue, and we can have this conversation, that perceived failures, perceived mistakes in who Republican presidents nominated to the Supreme Court led to an increased kind of anti-Roe v. Wade fervor among GOP activists. So what am I saying? I'm saying and I'm doing a little bit of a fast forward, like a preview for a new episode. What I'm saying is that by 2016, whoever was the GOP nominee, if they said enough anti-abortion things, could win over voters who might not seem like likely supporters. Okay, for those of you who remember who the candidate was in 2016, I'll get there later. But what I'm saying is maybe that candidate had to make explicit promises. And I'm going to get back to that. But my point is, Trump, the candidate in 2016, knew that if he sang the right song and promised to appoint justices who would overturn Roe v. Wade, that he had a chance at winning the election. And as a little bit of a preview, in 2016, 25% of voters said that the Supreme Court was one of their top issues when they voted. So remember, a quarter of overall voters said they were Supreme Court voters. Of those voters, they voted 6-4 Trump versus Clinton, right? So that's just a little bit of a fast forward showing how the desire to overturn Roe v. Wade has completely influenced our politics, okay? So I'm going to kind of quickly get us from 1980 to 2016, and then I'm going to stop in 2022, and we'll be all caught up, like live when you're watching a DVR. And then hopefully we can open it up and have some conversation. Sound good? You don't have a choice. Okay. So Ronald Reagan nominates Sandra Day O'Connor in 1981, Antonin Scalia in 1986, William Rehnquist gets elevated to Chief Justice in 1986 as well, and he nominates but fails to get confirmed Robert Bork in 1987. I can assure all of you that Bork would have voted to overturn Roe v. Wade. You could have asked him yourself. He did not believe that the decision was correctly decided. So Anthony Kennedy ends up getting that spot. Then George H.W. Bush wins in '88, and he nominates David Souter in 1990 and Clarence Thomas in 1991. And I just want everyone to now look, and if you're counting, right, if I had like the telestrator, like this was on football, at this point, it looked like the numbers were right to overturn Roe v. Wade. All right, so it's 1992, and if you count Byron White, William Rehnquist, and then all those Reagan and Bush nominees, we're all doing the arithmetic, that should get you to overturn Roe v. Wade. What we have is a case called Planned Parenthood versus Casey in 1992. And initially, when the case was argued and they voted, they were going to overturn Roe versus Wade. This involved a review of a bunch of laws in Pennsylvania, but also whether Roe itself should be overturned. And I don't know why this hasn't become a movie, right? But they took a vote, and then in the middle of the night or something, Kennedy, O'Connor, and Souter got together, and basically said, we can't do this. Let's write a joint opinion. And you have Kennedy, O'Connor, and Souter, and then you have Blackmun and Stevens. That's 5. And ultimately, they said, we're gonna uphold Roe v. Wade. A generation of women have relied on Roe v. Wade. The arguments to overturn it are not stronger than the arguments to uphold it. Okay? So think of the disappointment from party activists who had supported candidates that wanted to overturn it, right? I just want you to sort of think of that in 1992. Bill Clinton lowers the pressure a little bit. He says he wants to have abortion be safe, legal, and rare, right? So he's still pro-choice, and he nominates Ruth Bader Ginsburg and Stephen Breyer, but he wanted to sort of lower the temperature. George Bush becomes president in 2000, George W. Bush, and he nominates 2 justices, Roberts and Alito, who are anti-Roe, but with Anthony Kennedy still on the court, there are not enough votes to overturn Roe v. Wade. So now it's 2016. And in the 2016 election, again, I had never seen a candidate so explicitly make promises. Now, I would argue it was because Trump had more to overcome to prove himself to social conservatives. As many of you might recall, social conservatives had their candidate, and that was Ted Cruz. But when Ted Cruz dropped out, Trump had to court those voters. And this is where I'm taking my lawyer hat off and just saying, Donald Trump made 3 nominations to the Supreme Court: Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett. If you add Clarence Thomas, who was already on the court, Samuel Alito, who was already on the court, you have your 5 anti-Roe v. Wade justices. So basically, since 2020, the question has been, when? And ultimately, the answer was in the case of Jackson Women's Health versus Dobbs. So the case that's in front of the Supreme Court now involved Mississippi doing a near total ban on abortions after 15 weeks. The case was argued on December 1st, 2021. And oral arguments do not always perfectly preview how a case is going to turn out. Famously, the Affordable Care Act cases, when they upheld Obamacare, were kind of a disaster for the Obama administration, but ultimately they upheld most of the laws. But if you asked me, I would have predicted that there were 6 votes to uphold the Mississippi law and overturn Roe v. Wade, or at least 5. And Sonia Sotomayor early on basically said, how are we going to overcome the stench that the only thing that has changed on the Supreme Court is its personnel, not the legal arguments or anything else? How can we even say this is law? And in May, we got a draft opinion that looked exactly the way I would have imagined the opinion to look. What do I mean by that? So let me just give a quick overview of the draft opinion, then move into implications, and then we'll chat, okay? The draft opinion, written by Samuel Alito, and it looks like joined by Thomas and the 3 Trump nominees, Barrett, Gorsuch, and Kavanaugh. Fundamental rights come from 2 sources. One source is that they are written down in the Constitution. The other source is something deeply rooted in our nation's history. And that can mean whether your children go to public school. There are a lot of kind of narrow rights that we've decided are deeply rooted in American history. And Alito looks at history and says, there have been bans on abortion throughout history, and Roe v. Wade itself was very sloppily written and reasoned. He said, and then he did what I knew he would do, which is he quoted liberal law professors who critiqued Roe v. Wade. He quoted former Justice Ruth Bader Ginsburg saying Roe v. Wade went too far, too fast. And he basically said, this is an issue that can be handled by the political process, and the court should never have gotten involved in declaring abortion a right because it's not a deeply rooted right in our Constitution. The leak was electronically scanned and uploaded. It was a very 2022 story. This was not like off-the-record conversations with a reporter. Someone took it. The main theories, there's a few theories here, I'll offer them. One theory is that it was someone from the conservative side trying to avoid a Planned Parenthood v. Casey where justices defected, get it out in the public, which shows there were 5 votes to sort of lock in those 5. That's one theory. The other theory is it's a liberal justice trying to sound the alarm and say, hey, America, pay attention. This major case is being overturned. And then the other theory, and just to me, those are both plausible. The other theory is one that came in on an email from someone at Northeastern who co-opted the Supreme Court in 1974 and just said to me, you know, in the printer and reporter's office, there's like 10 or 15 employees. They can just run one off, print it, and go leak it to a friend. We'll see, but I don't care that much about who leaked it. I care more about the substance of the opinion and what's going to happen next. Okay. In general, there are going to be states that have what are called trigger laws, that have, meaning their states have passed laws saying when, not if, when Roe v. Wade gets overturned, immediately we will ban reproductive access, okay? Other states, like my home state of California or here in Massachusetts, will still protect reproductive freedom. What it's gonna mean is that where you live is actually gonna have a much bigger effect on reproductive access, and it's gonna mean that people are going to be probably having to travel if they want to terminate a pregnancy if they live in a state where it is criminalized. The last thing I will add in that I think is a very troubling aspect of our politics are these so-called bounty laws or vigilante laws that have popped up. Texas passed a law called SB 8, and it was creative, and I do not mean creative as a compliment. I mean it just descriptively creative, which is it took the government out of enforcement and let individuals sue anyone who aids or abets an abortion. That could mean an Uber driver, that could mean a physician, that could mean a hotel who let someone stay. But there's a lot of things I don't like, but what I also don't like is this notion of people looking around in their communities and neighbors for people to hunt down and sue with a financial reward. To me, that feels deeply un-American, and it's problematic, and it's actually being copied in some other states as well. So what am I saying? If Justice Alito, in his opinion, thought that this was the end of the court being involved in these disputes, I strongly disagree, because there's going to be a whole host of other issues, including interstate travel and other issues that I think are going to come up. So I think what we're going to see over the next week or two is going to be a lot of difficult conversations and a lot of debate. And the main thing that it's going to do is it's going to throw politics in the middle of this before we have midterm elections. And it's going to push, I think, many candidates to take a strong side one way or the other. And that means that the results of the 22 midterms are going to be very important. Okay. I just spoke for about 30 minutes, a little longer. Most of you are still awake. Oh, thanks. You're trying to keep yourself awake? Okay. Any questions, thoughts? I hope some people either had something to say or clarifying question. Anyone? Yes, in the front. Okay.
Basically saying that if in fact it is overturned, the individual states still have a right to not ban abortion.
Correct. Okay. Thank you. So, Ms. Moore has asked a very good question, a clarifying question. What are the political and legal implications of the Supreme Court overturning Roe v. Wade? Think of Roe v. Wade as a floor. Roe v. Wade provided a floor, meaning every single state must allow abortions pre-viability. In other words, any state law that banned abortions pre-viability was per se, as lawyers say, or automatically unconstitutional, right? That was the rule. The rule was an outright ban was unconstitutional before viability. And those who were following Mississippi saw, as soon as Ruth Bader Ginsburg passed away and Barrett was on, Mississippi said it in the record, well, now it's time. And they passed that law. What's amazing is that the 15-week law in Mississippi currently is actually more of a compromise and more moderate than a lot of laws that have followed the so-called heartbeat bills that we've seen. What's the point, Roz? The point is there's no floor or ceiling. What I'm saying is states are now basically free to do what they want. This is based on the draft opinion that I just want to be clear is not published or official. But the draft opinion does not include there must be an exception for. It basically says courts are no longer in this business. Does that answer? Okay. Same question or no? The Family Row, okay. By Joshua Prager. Yep. Right. History can unfold in unplanned and unexpected ways. Right. Yeah. Okay, great. Yes, Auntie Judy? I mean, sorry, Ms. Michigan?
That's fine. So according to what I hear you say about the states having certain rights, are these states' rights permanent, or are they able to change with political vacillations?
Great, okay. So Ms. Michigan asks about the fact that it's now up to the states. How permanent are the state laws and rules? Remember what Frankfurter Brandeis, I think maybe Brandeis said, right? States are laboratories of democracy, meaning that state laws can change. Some states are dominated by anti-abortion activists. Others are dominated by pro-choice activists. So no one here is going to be shocked that the states that have the highest number of registered Democrats are going to offer the most protection. Believe it or not, my home state of California, the governor, Gavin Newsom, has offered California as what he calls an abortion sanctuary. In other words, come to California and we'll take care of you. We'll put you up, right? We'll handle your lodging and care, right? So I think what's going to happen, and this has happened through natural geographic sorting and other issues, is that the quote-unquote red states, the conservative states, are going to get redder, and the blue states are going to get bluer. And for those of us that are able to choose what state we live in, that sounds like, okay, you know, the term vote with your feet, but plenty of people are in situations where they can't decide where they work, where they live, where they're born, right? So that's just something else to consider. When you think about the path toward marriage equality, a lot of people used to say, like, well, Massachusetts has same-sex marriage, just let people move there. And it's like, well, there's a lot of people for their job and some who are serving in our armed forces. They can't decide where they live, right? So it's just something to think when people say, oh, come on, you can decide where you want to live. That's not always the case. But the answer is, yeah, you have to change your state's politics. Now, one way you can do that is try to amend your state constitution, but the safest way is to elect politicians who share your values on issues you care about, right? I guess I would say that's the safest way. The interesting thing about the political relationship between people opposed to abortion and the courts is that the incentives were for increasing extremism against abortion with the knowledge that the court would always strike something down. So some analysts have said, maybe there's a chance. I just want to be clear. 81% of Americans think abortion should be legal in some circumstances. I am not saying all, but some. Let me flip that for you. 19% of Americans say it should never be permitted, even in case of rape or incest, right? So I just did the 81 and the 19. I was saying the same thing. What some observers have noted is, well, now, when you run on something, you don't have the courts to save you. And about a third of voters in the Republican Party call themselves pro-choice. Does everyone see where I'm going? They could always vote for Republicans knowing that the court would allow their pro-choice values to be carried out in public policy. If you remove the Supreme Court, which is going to happen in the next week or two, will those voters stay home or switch parties in the 2022 midterms? I don't know the answer, but that's been something floated about if there's going to be a quote-unquote blue wave in the fall, this would be the circumstances under which it would occur. Why? Because gas is $700 a gallon right now, and what happens to presidents in their second year midterms? They all get whooped up, is the political science term, or shellacked. It just happens. There have been 2 exceptions to that pretty much ever. Bill Clinton in 1998, when America had impeachment fatigue, and 2002, when people were still incredibly scared after 9/11. Every other midterm election has always meant decisive victory for the opposition party from the president, right? So take away 1998 and 2002, the opposing party always gained seats. Okay, so I just said a lot there, but my point is, maybe overturning Roe could mean that Biden doesn't lose as badly. That's how optimistic I am, that he loses less badly. All right? Hi. Do you want It's like an aliyah. It's like an aliyah. Yeah, it's a little bit, right?
Could you speak about how hard it will be for someone who wants an abortion from a red state to make it to a blue state?
Okay. How hard reproductive care be for someone who lives in a state where it's a crime? Is that okay? So I guess my answer is harder than before, but not impossible, because people are probably familiar with this term, mutual aid, right? Sort of networks that will grow, apps that will be built, nonprofit groups that will do work. I don't want to pretend it will be as easy as it was before, but I just want to note, Mississippi had one clinic when Roe v. Wade was good law. So I don't want to suggest that a lot of these restrictive states were easy places anyway. So what I'm saying is, this opinion is going to make very hard states become impossible for abortions, if that makes sense. It's already very difficult. But I guess I would say that kind of networks that I've followed have made me think there will be ways. And by the way, in the wake of basically the outlawing of abortion in Texas, a lot of Texans have been able to have abortions in other states using the resources to which I referred. But then I think everyone here can think about your phone and tracking apps and all the, just think about if someone gets into power in the government who has not so good intentions, and they get a warrant and they can track your phone, right? There's just a lot of troubling concerns with the use of technology to surveil people, right? Because if something's a crime, you're allowed to get a warrant to track someone who's suspected of criminal behavior. So do you see the dangerous implications? Yeah.
Do you think that this ruling foreshadows what might happen to, for example, gay marriage and LGBTQ rights and transgender rights? Because it seems like it's sort of moving somewhat in that direction.
Yep. So this is one of the most ironic parts of the draft opinion. So the question from Mrs. Selby slash mom was basically, what other rights are at stake? Do I have that? Yeah, like, is it going to stop here? Samuel Alito, in his draft opinion, addressed what you just asked. He said, many are worried about the slippery slope or the implications of what happens next. And he says two things, and neither of them make me very comfortable. The first is, he said, well, same-sex marriage is not murdering a person. Okay? And I remember reading that and saying, like, okay. But contraception, according to a lot of people, is. So I want people to look up the case of Hobby Lobby, which involved a privately held corporation that said, we're not going to cover certain forms of contraception because that's murdering a baby. What am I suggesting? The logic can be extended to contraception, and like clockwork, more than one state has already introduced bills going there. Now, what makes me think that contraception and LGBTQIA+ rights are on more secure footing than abortion? Public opinion, which the justices pretend not to care about. But I actually think they do. And elites, while Americans are divided on abortion depending on how you ask the question, about 70% of the country is pro same-sex marriage, and about 85 or 90% of the country thinks that contraceptives should be legal. So I guess what I'm saying is, does everyone see the irony? Conservatives have said, don't worry, public opinion will support you, but public opinion overwhelmingly supports abortion being legal in some circumstances, so they're listening to it with one ear and not the other. So that's just an irony. So I guess my answer is, I think there will be types of contraception that will be harder to obtain. What a perfect way to stop.
I want to ask.
Yeah, please, go for it.
I'll give you two questions and
Yeah.
you decide which one is more interesting.
Okay.
Number one is in the Alito draft, does the reasoning in the draft follow the dissents in the cases that you laid out historically, or are there sort of novel arguments, legal arguments in the Alito draft? And the other question I have is about the overturning of precedent and whether or not, what one might make of that in terms of its ramifications for the court or the precedents for overturning precedent.
Great. Okay, I'll answer both. Those are both fun questions that Rabbi Rogozin asked. So the first, the opinion looked about what I would have imagined an opinion to look like, especially the way that it sort of, I guess you could call it trolling, the way that it sort of was using liberal sympathetic arguments against Roe, like that. I was somewhat surprised by how dismissive the opinion was of equal protection claims. So just to nerd out for a second on constitutional law, the 14th Amendment, which is one of the post-Civil War amendments, 13th, 14th, and 15th, that really changed the structure of American government and really emboldened our Constitution because the Bill of Rights did not have enough protections in them to outlaw slavery and prevent a civil war, right? We had to fix this document. The 14th Amendment has a due process part, which is where the privacy comes from, liberty, but it also has an equal protection part. Why are we making, one gender carry out a pregnancy, but we're not imposing these rules on males? And Alito gave it like 2 to 3 sentences. I promise when the dissents come out, those will be full of arguments for why this is actually an equal dignity and equal protection claim, that you're singling out women. So that was one part that was surprising. He sort of just dismissed it, and he cited like a 1974 case that's pretty much been overruled. So that was like maybe a little bit surprising. But the rest of it looked about what I would have imagined, which is this is for legislatures, not courts. So in some ways, Michael, it tracked the original Griswold and Roe. To your other point about stare decisis, remember, what's supposed to make law different than politics is that law is slow to change. The Supreme Court has turtles in their courtyard, and the turtles are supposed to represent the tortoise, slow, incremental change. This proves the old saying, which is actually attributed to Justice Bill Brennan, that the most important number at the Supreme Court is 5, because with 5 votes you can do anything. There's a brazenness to the new majority, but I think it's going to just mean that stare decisis is good until you have enough votes to overturn it. Right. I mean, like I said before, Planned Parenthood v. Casey addressed the arguments against Roe and said stare decisis is important. Well, it's been quite a while since Casey. It's been about 30 years. So if anything, stare decisis is stronger. So yes, I think it's going to actually increase public cynicism about whether law is really law and not just politics and power by other means. I feel more cynical when I'm teaching this stuff because ultimately, if it's not about principles, then what's it about? Maybe it's just about power. I think that's also a nice place to stop. All right. Thanks.
Thanks, Dan.
My pleasure.
Thanks to everybody who tuned in on Zoom. We appreciate your participation tonight.
All right.
Good night.
Thanks.
Now the real questions come.
Exactly. Yeah. Thanks for coming. Thanks for coming, JD. Thanks for coming, guys.